I'm Melisa Idris. Welcome to Consider This. This is the show where we want you to consider and then reconsider what you know of the news of the day. The Federal Court recently came to the decision to strike down 16 provisions in the Kelantan Sharia Criminal Code enactment on the grounds that they were unconstitutional. Now, Chief Justice Tengku Maimun Tuan Mat said that the decision was solely based on the jurisdiction granted to the state legislative body. However, despite this, the case has sparked uproar among certain groups who fear the ruling could undermine Islam and the Sharia courts. Joining us now to help us better understand this ruling and the significance of it in our legal landscape, we have Datuk Dr Shamrahayu Aziz, constitutional expert and lecturer at IIUM's Ahmad Ibrahim Kuliah of Laws. Thank you so much for joining us. Dato', I appreciate your time. Now, could you maybe begin by first helping us understand the significance of this ruling, particularly when it comes to our dual judicial system of civil and Sharia?
It is unavoidable that in the division of powers between the federal and the states, there must be questions. This is something usual in a federal kind of a government. So the impact or the consequence of the decision is that it has made clearer on the division of powers, especially on the criminal jurisdiction of the State Legislative Assembly and also the federal legislature, that is Parliament. What is provided for in the Constitution has been interpreted to mean that division of powers between the federal and the states is clearly provided or even embedded in the federal constitution by virtue of the item number 1, the 9 schedules, the federal list and also the state list, right together with Article 74. So as far as the decision is concerned, it's involved communal jurisdiction of the State Legislative Assembly, whether the State Legislative Assembly has the power or competent to make such provisions of law. So it has made clear to us that on certain matters, although it's involved the precepts of Islam or it may involve the Muslims, the federal legislature or the parliament still has the power to enact such laws.
So what then do you say to the people who fear that this case could undermine Islam or the Sharia courts? We've heard that rhetoric come out in the weeks after the ruling. So how would you respond to the people who say they are concerned?
I think we must look into, one is the history of the provision, and secondly, we look at what is the objective of the provisions. I think the uproar, we say in the consequence of such a decision is because all this while we understand that matters regarding morality, matters regarding purely the hukum syara or Islam in general is under the state jurisdiction, without realizing that there are provisions in the constitution which give powers to the parliament to make such laws, meaning to say to make laws on that concern with the harmony or with the concern with the criminal law that in the federal jurisdiction. So it may not be right if we say that only the state legislature can make law on matters that affect the position or the status of the Muslims, and also that may concern about matters regarding precepts of Islam. So it has been clearly stated by the federal court that some matters under the precepts of Islam are also concerned of the federal legislature, which is empowered by item number 4 of the first list in the 9th schedule of the federal constitution.
Professor, just a quick question. So you said that there's a perception that laws to do with morality and hukum syarat that falls under the state. Can the state legislature enact laws that are criminal, address crimes? Can they enact criminal laws? And what would be the conditions for that, for the state legislature to be able to do that?
Yes, item number one of the second list night schedule give that powers to the state legislature, but that power means power to create offence and provide for punishment on matters regarding offences that affect the Muslims, as well as that affects the Muslim and within the meaning of the precepts of the religion. However, there's a preclusion clause provided for in the same provision where, although the state legislature has powers doing so, but if the subject matter, if in the pith and substance, that is the terminology used by the courts in interpreting such provision, if the subject matter or the pith or the real intention of the law is for the purpose of criminal law, therefore that denies the jurisdiction of the state legislature. Then it falls under the federal legislature. So what the court did was that the court went through or read through the whole provisions that have been challenged, the impugned provisions, and the court determined the piece and substance, and the court inclined to say that, or the court decided that the majority of the provisions, except the two provisions, are for the purpose of criminal law.
Okay. All right. So the 16 provisions that the court has nullified, are those provisions unique to Kelantan, or are there other states whose Sharia criminal code enactments might also be similar and therefore contradict the constitution?
Yeah, there are some other states which has the similar provisions and similar offences provided in their law. However, as far as the recent decision is involved only Kelantan, and therefore the law that had been declared unconstitutional is only in the states of Kelantan. So it must be specific to the state of Kelantan. But then I believe that the states should also take consideration of the subject, and they should have do something at least to make law at the state level consistent with the decision of
Right.
the federal court.
So are we likely to see harmonizing of Sharia and civil laws now that states will be looking at making their laws more consistent with the constitution?
Here, of course, where we are having a written constitution, the federal constitution is a form of agreement between the states. Therefore, the states and also, of course, the federal, also the parliament also must abide with the rules provided in the constitution.
Right. Would that mean that if any of the laws that are not in line with any of the state laws that are not in line with federal legislation, would that require someone to challenge the constitutionality and the validity of those laws the same way we see the two petitioners in Kelantan? Would the same route have to be taken in other states?
The possibility of having another case of similar or of the same kind is there, but I believe it would be good for the states to evaluate the law before such case come to the court, and I think it is very much welcome, and we menjunjung kasih for Duli Yang Maha Mulia Sri Paduka Baginda for the Duli Yang Maha Mulia Sultan Selangor for making a titah that we should look into the state laws and how it can be harmonized, and how at the same time we can empower the Sharia courts. It's not necessarily that when the 16 provisions has been declared unconstitutional, it does not mean that the Sharia is no more part of the law of the land. So we should consider the states. I think the states should consider to re-evaluate the law or to making it harmonized, and to accept the facts that any law introduced later may empower the Sharia court, but it may not it may not affect the decisions that have been made by the federal courts.
Professor, can you elaborate? What do you mean by empower the Sharia courts? What does that look like?
If we look at the provisions of the Constitution, the Sharia courts has been, there have been amendment to empower the jurisdiction of the Sharia court. There is one example where the courts at the federal level will not encroach into what had been decided by the Sharia court, meaning to say there's no appeal from the Sharia court to the conventional court or the courts at the federal level. And there are other jurisdictions of the Sharia court which are more important for the Muslims, such as matters regarding the Aqidah or the belief of the faith of Muslims, matters like propagation of non-Islamic doctrines among the Muslims, that's very clearly under the state jurisdiction. And another matter is about some kind of morality like adultery, matters which are considered very much related to the hukum syara. Although other matters at the federal level or in the federal jurisdiction not necessarily consistent or inconsistent, we don't have to debate on that. But what most important for the Sharia court is to enforce what's already clearly within the jurisdiction of the Sharia courts.
Right. Just coming back very quickly to the federal court ruling, I'm just wondering, what does this now mean for the people who have been charged and convicted under Kelantan's Sharia criminal provisions? What does this nullification work in retrospect?
Okay. It's a very principle of law that any law which is being declared unconstitutional, it has a prospective effect rather than retrospective effect. What had been decided, what we call in the doctrine, is that the doctrine of prospective overruling for what is in the future, not what had been decided by the courts. So the presumption of the law, any law made by any legislature, it will be presumed to be a valid law, constitutional, unless and until it is declared unconstitutional by the court.
Okay. Professor, in the couple minutes that we have left, I do want to ask you, what message do you have for all of us who are trying to navigate these discussions that come up in the public sphere about religious matters, but in a way that upholds both constitutional and religious principles? Do you have any insights to share?
Is of course that as Malaysians, we must understand our law. We must respect the decisions of the courts. We must explore more what had been intended to be for the Sharia courts. And of course, Islam should not be undermined. Similarly, like the Sharia court, the Hukum Syara should not be undermined. And we must refer to the constitutions and to the ideology of the nation that we consider, or we must accept and uphold the principles to establish the supremacy of the Constitution, as well as at the same time respecting whatever had been given by the Constitution or entrenched in the Constitution regarding the position of Islam, the position of Sharia courts, and the position of Hukum Syara in general.
Thank you so much for speaking with me. That was constitutional law expert Datuk Dr Shamrahayu Aziz. We're going to take a quick break here and consider this. We will be back with more. Stay tuned. Welcome back to Consider This. I'm Melisa Idris. Thank you for staying with us. Let's continue our discussion about the fallout from the federal court's decision to nullify 16 of Kelantan's state Sharia criminal provisions. Now, given the uproar among some groups over the ruling, police have cautioned against engaging in extreme sentiments and provocations, including on social media. So how can we as a society have constructive conversations about issues like these without exacerbating tensions or promoting divisiveness? Joining us on the show now is Dr. Ahmad Farouk Musa. He's founder and director of the Islamic Renaissance Front, which describes itself as a movement promoting intellectual discourse on Islam. Dr. Farouk, thank you so much for being on the show with me today. How would you respond to concerns raised by certain groups that regarding the potential of the ruling to undermine Islam or the Sharia courts? What would you say to them?
I think, in short, I would say that there was the misunderstanding about the whole issue. The entire issue was basically to say that the whatever the Kelantan State Legislative Assembly was trying to propose was actually in excess of the federal constitution. And I think that if we know that according to our federal constitution, there is what we call as a federal list and a state list. So state cannot enact any laws that have been enacted by the federal constitution in simple words. In simple words, I would like to say that. Okay. I'm not talking about legal jargons, but in simple words, we're going to say that state cannot basically have a law similar to a law that has been enacted in the federal laws. For example, sodomy, right? Sodomy, homosexuality, sodomy. Okay, state cannot have a law on its own to punish sodomy, right? Because it is under federal law.
Mm.
So that's very simple understanding what it is all about. So I would like to say that it is not about undermining the status of Islam in this country, but it's basically to put Islam where it's supposed to be according to the federal constitution. And it says clearly that Islam is the religion of the federation, right? So basically, that we have no issue with that.
Yeah.
And,
So,
and yeah,
yeah, I mean, the experience of Nick Ellen and her daughter Tengku Yasmin, what has that? I mean, with all the death threats and the words thrown towards them, what has that said to you or taught you about the ways in which that we as a society, as a country, can have discourse, civil discourse about issues that are sensitive, that are related to religion, while respecting diverse perspectives?
we hope that we'll be able to do that. Be able to have a civil discourse on this matter. But what I see on the ground is that this whole issue has been blown out of proportion, and it has been um, how do I say um, it has been portrayed as an element of the liberal segment of the society that was trying to basically undermine the status of Islam in this country. So, the issue is that now they are trying to say that the liberals are trying to say that the Muslims cannot have this and cannot have that, and we have to the liberals wanted Malaysia as a secular state, and I think this is a very problematic issue, because in a way that we do not have that kind of civility as you mentioned just now. This civility is basically lost in this whole discourse. But before I forget, I wanted to raise this up. This morning it came to my mind that why was it that this particular issue was being launched by Nick Ellen herself and not the AG chamber? I think the AG chamber should be the one who be taking a proactive measure to launch this against the Kelantan State Legislative Assembly, not Nick Ellen. So why do we have to put Nick Ellen in this situation? And one dissenting judge said that she has no local standard in this matter, right? Instead of the AG chamber itself. That was something that came out to my mind this morning, and I wanted to say this before I forget.
Do you think that for other states, so this is specific to the state of Kelantan, but other states I'm sure have similar provisions, criminal provisions within their state legislature. What do you think what will happen given the experience of Nick Ellen? Do you think there will be other challenges to state laws? And would that require a petitioner to come out and walk the same path Nick Ellen and her daughter had walked?
Well, if you were to read my statement, at the end of the statement, I mentioned something about Schedule 9 and the state list of the federal constitution, which says that state has the liberty to enact laws against the precepts of Islam, and that to me is very problematic. Like, we have a lot of laws everywhere in Malaysia, particularly in Terengganu and Kelantan, where they enact laws that, for example, um, if you don't perform Friday prayer, for example, you can be apprehended. And to me, state can have that kind of laws because it is within the precepts of Islam. What they think is against the precept of Islam, so they can have that kind of laws. But the issue is that, as I mentioned in my article, was that to me, that kind of laws, you know, I'm not saying that they're draconian. I think the word was too big to say that. But to me, to enact such a law, meaning to say that you are trying to impose piety among the Muslims, whereas piety is basically up to individual. Piety is between you and God. So meaning to say that if you want to perform Friday prayer, it's because you feel it's your obligation to perform Friday prayer, not because you're afraid of the state apparatus. That if you don't perform Friday prayer, you're going to be apprehended by the state apparatus. That's wrong. That's not piety. There's no piety. To me, these kind of laws were basically creating a community of hypocrites, right? And I think that that's very important for us to understand this, and I think it must. Um, uh, I mean, the audience out there must be able to appreciate this. Yeah.
There was a comment that was made by Selangor Amanah, which I thought was quite interesting. And they said that the petitioners, Nick Allen and daughter, should have used, if I may quote their words, more harmonious avenues before taking the matter to court. Do you think that taking it to court was the right avenue?
You see, I read that particular comment by Amana as well, and I think there was the main problem with Amana. I do not know about the federal Amanah leaders like Mujahid and the rest, but these are like state leaders, right? They should not have come up with that kind of statement because it shows that they still have that past mentality in them. What do they mean by harmonious? I don't understand the meaning of the word harmonious. What do they mean by that? Could they give an example what they meant by being harmonious rather than Nick Elling challenge it in court of laws?
Right, so let's talk about that. What platforms are available to us? What strategies are at hand that we can use to facilitate this type of discussion? So let's take it at face value. If they say one avenue is to go to the courts, but other avenues are more harmonious channels, then where can we go for respectful conversations and discussions about religious matters within Malaysian society? And is there a place or space for non-Muslims within that discourse?
You see, from the comments by my non-Muslim friends, they're very scared to talk about this issue because it's a very, they say that it's a Muslim issues and they don't want to get involved. But of course, they would like to see that, we basically move forward as a state that has been envisaged by our forefathers, right? Basically, it was supposed to be a secular state. Meaning to say, like, well, I've been harnessing about this particular issue about this secular state because when I talk about secular state, doesn't mean the Kamal Atatürk type of vision of a secular state, where you have to basically disregard Islam altogether from society and from the state itself. You put state aside and Islam aside. It's not that. It's basically what we call as passive secularism, where there is kind of a tolerance between the two, between the state and the citizens, and the citizens toward the state. So I think that's more harmonious way in trying to go about in getting in having this kind of discourse in the society. And I think the more, how do I say, intellectual section of the non-Muslim society should come into the debate and to participate together with us in this debate, and not to leave to us alone to talk about it, right?
Yeah, in all your years of, encouraging intellectual discourse around issues of Islam, What would you say are the ways that have worked in terms of engaging those who hold different views? Where can we start?
Well, the best I would say is that to hold a roundtable discussion, to have past leaders and to have the liberals on the other side, and to hold, a kind of a dialogue between the two. I had proposed to Gerakan, because Gerakan is, as you know, is on the other side of the fence. So I proposed to Gerakan, to hold an event where they can call the past leaders, and can call me and a few others as well, to come and talk to them and have a dialogue with them, and see where we can work together on this particular issue, and not to make it worse for our country, right? And I think like everybody wants peace in this country, and everyone wants to move forward, right? And basically we are more concerned about our economy now. A ringgit has been sliding, and these kind of issues are not making it better.
Right. Well, thank you so much for speaking with me. That was Dr. Ahmad Farouk Musa from the Islamic Renaissance Front, wrapping up this episode of Consider This. I'm Melisa Idris, signing off for the evening. Thank you so much for watching. Good night.